Thank you all for attending this third panel, and without further ado, I'm going to turn it over to Judge Lucy Coe.
Good afternoon and welcome back. Please try to avoid the post-lunch food coma. We have a great panel today. Let me introduce them briefly, and then we're going to vary our format a little bit. First, we have UCLA psychology professor Paul Abramson. The LA Weekly called him the, quote, sexpert, end quote. He's authored numerous books, including Romance in the Ivory Tower, The Rights and Liberty of Conscience, and he is the lead singer and lyricist of the band Crying for Kafka. Next, we have Harvard Law School professor Jeannie. The Boston Globe called her one of the 25 most stylish Bostonians. That's true. She authored the book At Home in the Law, How the Domestic Violence Revolution is Transforming Privacy, and she was a prosecutor in the Manhattan District Attorney's Office. And last but not least, we have Stanford law professor Bob Weisberg, whom the Boston Globe called one of the 25 most stylish co-directors of the Stanford Criminal Justice Center. He co-authored the book Literary Criticisms of the Law. So we're breaking this panel up into two segments. The first segment will give each panelist 5 minutes to address the question, what is the range of conduct universities should prohibit? Then each panelist will have 5 minutes to respond to the other panelists' answers, and then we'll have 15 minutes of questions from the audience. And when you ask your question, if you would please direct it to a specific panelist, certainly not to the moderator. And then the second phase will be, should consent be the standard for sexual relations on campus, and if so, what does that mean? And in that topic, we would like to include nonverbal consent, intoxication, developmental disability, affirmative consent and what that means, and consent at what stage in the relationships. So, and we'll follow the same process of 5 minutes, 15 minutes of audience questions. All right, so with that, let's start with our sexpert, Professor Abramson.
Thank you all. Thank you for the invitation. It's an honor to be here with panelists and moderating and so forth. As kind of a preface, I just want to give my sort of version of trench stories. For the past 40 years, I've been an expert witness in civil and criminal litigation involving sexual assault, sexual abuse of kids, rape, and so forth. Primarily for the plaintiff side, the prosecution side, but not exclusively so. For the past 15 years, I've been a pro bono expert witness for the Santa Barbara District Attorney's Office in all the egregious sexual assault cases, rape, murder, and those sorts of things. And I teach the sex and law class at UCLA, and many of the things that have been discussed thus far, although I am in agreement with the sentiment of such, I have very different points of view. And kind of using that as a lead-in, I don't believe that sexual misconduct should be under Title IX. I think that this is something that should be handled through law enforcement, and I actually don't like even the phrase sexual misconduct. It's kind of a euphemism that's inappropriately applied. The victims don't appreciate the title as well. In my thinking of this, the metaphor I use is theft. Sexuality is an incredibly private, valuable, well-guarded, and fragile part of our self-identities. If somebody takes part of that without consent, to me it's a form of theft. And it's not like someone's stealing my car where it's insured or some other aspect like that. It's deeply personal, and the reactions to it are very deeply personal. And I don't think that universities should be in the business of regulating theft. Certainly in my department, if someone steals a laptop or breaks into a lab, the department doesn't get together and discuss what we're going to do with this person and investigate and so forth. You know, this turned over to law enforcement. And when law enforcement prosecutes a case, these sexual assault cases that I'm involved in, they use collateral witnesses, collateral evidence, pretext calls, and all these other sort of things so that they build cases. And it's the same for the defense side. They build cases. And so I think it's the people's heart's in the right place, but I just don't believe that it fits under the umbrella of Title IX. I think for that should be limited to sexual harassment, quid pro quo, or hostile environment, and so forth. And so my answer to this particular question, what business or what university should be prescribing, is limited really to professor-student consensual relationships. And from my vantage point, it's not a question of whether universities should encourage or exempt those sort of relationships, but whether we should protect the choice to engage in those relationships or preclude that choice. And these are adult, and given sort of my history and the work I'm involved in, for consenting adults deciding to be in romantic, and I use the word romantic because the UC descriptions of this are both sex and romantic or sexual relationships, this is their choice to do it. And I think there's a constitutional right for doing so. And the way I think of this in terms of liberty of conscience. And this is something that our esteemed conference organizer and I disagree about, and I could never articulate that as eloquently as he has articulated it. But I believe that when the First Amendment and the Ninth Amendment were ratified on the same day, that Madison looked at this in a certain way and figured that the more generic right is the liberty of conscience, and the more specific enumerated right is the freedom of religion, like the freedom of press and speech and so forth. So they ended up in the First Amendment, and I believe his intention was to leave the rights and liberty of conscience in the Ninth. I think it's evident in his inaugural address, is evident in writings of Jefferson and so forth. And I think it all kind of fits within the basic notion of the ability, even if you don't agree with my argument, just the ability to think, choose, and judge. We think, choose, and judge about our gods. We think and choose and judge about our religion. We think and choose and judge about voting. We think and choose and judge about love. And choosing a romantic partner is a prerequisite for romance. So precluding the ability to make that choice with consenting adults. And I'll briefly say something, the arguments against this, one of which is power imbalance and the other is favoritism. And I'm sympathetic to those things. I just don't think those are reasonable rationales for precluding it on college campuses. We don't preclude doctors from dating nurses, lawyers from dating paralegals, actors from dating directors, and the list is long. Even if you walk in a club, that gives you a power imbalance in that as well. The favoritism part, I'm much more sympathetic to. That, academia is a fiercely fought environment, competitive environment, and we're going to favor those who we love for romance. So I would suggest that we use policies, conflict of resolution policies, and like recusal and disclosure. So if you're adult enough to have a relationship with your student, TA or professor, you're adult enough to disclose it to your chair or somebody else in charge and get a third-party evaluator.
All right, thank you. Professor Sook?
Thank you. So I want to start with a statement that I feel is very important, but that increasingly on universities is getting lost. That there is a distinction between sexual assault and sexual harassment on one hand and sex on the other. And the reason that for some of you that may seem really obvious, that what we want to prohibit is the stuff that is sexual harassment and sexual assault, but we don't want to prohibit the stuff that we would call sex. That does seem obvious, but actually in reality today, it has become very difficult to actually attend to the difference between them. And that has to do with the expanding definition of what we know in the universities today as sexual assault, sexual harassment, and sexual misconduct, right? The euphemism that Paul was talking about. And so when you look at, in the old days, it wasn't as hard because people generally thought about sexual assault or rape as something that happened when you held someone down and forced them to do it or threatened them in order to get them to do something. But we know today the vision of sexual assault, sexual misconduct on universities, by and large, thinks that that is on the very extreme end of the bad things you could do. But overall, the kinds of things people are talking about as sexual assault do not involve force. They do not involve threatening someone or coercing them overtly by saying something bad will happen to you if you don't do X, Y, and Z. And so in general, a lot of the cases that, for example, Andrew Miltenberg has dealt with and other litigators and people like myself who have seen a bunch of these university cases as they make their way through the university system, is that even the allegations do not allege things like forcible conduct. What you're talking about is sexual assault or sexual misconduct defined by the university in a way that has nothing to do with force. And I think that we're in that world already. And at that point, then what is it that makes the conduct unlawful or out of bounds in a university committee, in a community? And generally that concept is consent. And we're going to talk more in detail in the second part of this panel about what consent is or should be. But it's when you're in a world of consent as opposed to force, then it gets trickier to say what exactly is sex and what exactly is crossing over into what we might term sexual misconduct. I think that this morning, one of the questions that came up was, is sex different? And Paul actually just alluded to this as well. It seems very clear that there is a kind of back and forth in this debate between saying sex is totally not different. It's like, look, we have to punish arson and we have to punish theft and robbery and it's not different. The university ought to be able to deal with those things and plagiarism and all. And when student hits another, and why should we say that we shouldn't deal with when people harm each other sexually? That makes no sense. On the other hand, I think that there is an intuitive sense that I have as well that sex is different, and that it is a kind of when something happens inside, but both the good parts and the bad parts, they have a certain level of intimacy and something that a lot of people consider to be among the most private things they do. And for that reason, there are justifications for treating it differently. And it's a question of in what ways you're going to treat it differently and how you're going to respect that realm of privacy that people associate today with sex, while also understanding that when it crosses the line into what we call sexual misconduct, we're going to discipline it. I think that we are in 1987, Catherine McKinnon said, politically, I call it rape whenever a woman has sex and feels violated. And I think in 1987, people understood, well, that's not legal, and that's not ever going to be enforced, but people thought, well, politically, you can think that, and that you may disagree or agree, but that was the statement. And 30 years later, I believe that in our universities, we are in the process of very much catching up with that idea, that it may be, maybe not rape, but what we might call sexual misconduct, when a person, and not necessarily only women, when a person has a sexual encounter and then maybe feels violated right then, or maybe feels violated later and realizes later that what happened in the moment was not okay for them. And I think that we need to really attend to this. I myself am not in favor of defining prohibitions along the boundary of a particular person subjectively feeling violated. But beyond that, it's still a very difficult question how to define the boundary, because there's force on the one hand, and there's feeling violated on the other hand. I don't want either of those to be the boundary, but then there's a whole space in between, and I think that we're going to talk more about this in the second part.
All right, thank you. Professor Weisberg?
Thank you. Let me just first note at the start that there has been a simultaneous symposium at the law school today that I was part of, so I did not have the benefit of attending the morning panel. And I apologize in advance if anything I say repeats what was said there. Particularly the reason I raised that question is that I'm going to somewhat finesse the question that Paul and Jeannie have addressed pretty directly about whether sex is different and in what way. I want to pitch things a little more generally and wax a little more philosophically about how a university decides in the first place why it bans anything, which is to say, inevitably, and again, this may have risen in this morning's panel, the question of the relationship between university and the outside law. And you could do a little kind of matrix or taxonomy of things. You could say that a university should forbid that which law otherwise forbids. You could say that a university should only forbid that which is not forbidden by outside law, but for some reason should be forbidden inside. And even then you could spread out the matrix a little and say, well, it's not just a question of what is formally declared illegal, in the outside world, but what is informally prosecuted is illegal, which is a very different and largely much smaller denominator. And the general point, if we obviously look at all kinds of things and not just sex, is that universities are all over the map on the place. And that doesn't mean there's hypocrisy. It just means that there's no simple answer to it. There are many, many things which are forbidden on campus, which are not illegal, except by some phenomenal stretch of the law. So, for example, I don't think plagiarism is generally a crime, unless, of course, and this is part of my white-collar studies, unless a federal prosecutor decides it involves federal wire fraud, but that seems a bit of a stretch. There are thefts on campus, which are certainly thefts and could be prosecuted by the local prosecutors, but the university often deals with in different kinds of ways through all kinds of civil settlements. But there's obviously a very strong argument that when it comes to very serious harms, and I'll simply add, of course, on a subject which is very, very complicated, of course, in relation to sex, and at this point I don't mean to raise at all the question of the relationship between the two. Simply note that universities do not forbid, generally, underage drinking, or they often don't, even though, of course, that criminal act is occurring all the time in universities, and there are all kinds of perfectly good reasons for that. So just to say then that universities don't have a formula for this, and I think the kind of general tropism runs something like this, and perhaps should. Number one, there are peculiar areas of interest in universities that are central to their role as universities, and this is often put under very vague terms such as, the importance of, educational access, the integrity of the professor-student relationship. Clearly, universities do and probably should forbid things that may not be flatly illegal under outside law if they go to the core mission of the university. Universities may have to sometimes illegalize things which are illegal elsewhere, but which, for all kinds of practical reasons, will never be prosecuted. I think that's a very, very legitimate, argument. Even then, though, and this is where the substance procedure matter gets pretty blurry, to say something should be forbidden or not forbidden is only a small step along the path to your conclusion, because, of course, the question is forbidden in what way, with what kinds of sanction. What kinds of correlations, if any, should there be between inside punishments and outside punishments? So I guess I will just, mildly disagree with Paul. I do think that there are lots of things that universities probably should forbid beyond what he says they should forbid. But I think in doing so, one has to attend at some general level to the general question of what the relationship between inside law and outside law should be. And I think Jeannie, as she said here, and as she and Gerson have been writing about in really, really interesting scholarship, if we do decide that sex is different, we have to take on issues about the different types of sexual activity, the different themes about sexuality that criminal law itself does a really, really bad job on the whole of addressing.
Thank you. Professor Abramson, would you like to respond?
Yeah, I respond briefly to, or at least give my definition of sex. To me, it's an umbrella construct, and it's filled, and underneath which are all these discrete acts, circumscribed discrete acts, and from those, if consent is not given to any of those discrete acts within it, to me, it's sexual assault. And you can see this developmentally. You ask a 12-year-old, where's their boundary? You ask a 14-year-old, where's their boundary? And so forth. And it's not something that we routinely share, or if we do, we want to have the discretionary choice of making that sharing. If it's taken from us, any of those discrete steps, it's sexual assault. And whether it happens on university campus or outside university campus, to me, is irrelevant.
So I think that the idea that the university should get out of this business altogether is in many ways appealing, but it is, I think, quite impossible, because as a community, there is going to be a need to say what are the things that we find unacceptable in any realm of life, including in sexuality. And it doesn't make sense. Just as Michelle Dauber said this morning, it doesn't make sense to say in everything else we're going to punish people for doing things like plagiarism or hitting someone, but just because it's sex, we're not going to touch it. That doesn't make any sense. And it also, but it also means that the university has to recognize that sex implicates interests and is in its nature, in the way people think about it, different from, say, deciding to steal something from another person or set fire to a building. They're just very different things. For one thing, sex has a lot of ambivalence that is inherently caught up in it. When it's about, it involves two people and their interaction, and you could have the exact same interaction physically happening, and the meaning of it could be completely different depending on how the parties are thinking about it. And it could be that you could watch a videotape and it could go the exact same way physically, but that the same set of facts is sexual assault depending on things that happen either before or during in the people's head, or in another situation, the same set of facts could occur, but it's not sexual assault because of the way the parties thought about it. And in that way, it's very different as an adjudicative matter, as a matter of investigation. And so I think that this line drawing between sex and everything else is not easy, but I also think that it's essential that we understand that there is a line between activity among people that does not implicate our rules about what's not allowed. And that's just become really tricky today. And the reason is that a lot of the expanding definitions of sexual misconduct on campuses today actually really do implicate conduct that almost everybody engages in. That when I look at the sexual misconduct codes of my school and of many schools today, it is clear to me that almost everybody has violated those codes at some point or another. And what that basically means is that we have a situation like disorderly conduct or loitering laws that basically sweeps so wide that anyone actually can be brought up on charges. But of course, not everybody will be. It will be selectively enforced. And that selection will depend on the subjective experience of the person who brings the charge, and also on the morality and the perspective of the university officials who take a look at the facts. And that is the situation that I think is very, very troubling to me. The idea, not that we should have rules that are enforced in the university, but rather that these rules today are so expansive and so broad that really almost anyone is validly coming under their reach, and that the people who are getting accused, the people who are getting kicked out of schools, are experiencing this in a way that is, I believe, racially and disproportionate based on their class status and on basically like maybe being a little weird. I think there is a way in which it is being enforced against some people and not enforced against other people. And this is a real problem. It actually takes away from the legitimacy of the project of trying to basically tell people in the university this kind of sexual conduct is not acceptable. When you have broad rules that basically touch everyone and make all of our sexual conduct against the rules, then all of the entire system actually looks pretty illegitimate, because it feels very arbitrary in terms of who's being brought up on charges, who's being punished, who's being expelled for what. And that's the main problem that I think that we need to address today. In our fervor to actually say we're going to be really serious about sexual misconduct, we take it really seriously, broadening the definitions so that so many things fall under it, that's not a solution.
I extrapolate from what Jeannie said, a respectful disagreement with Paul, of course, that it may be beside the point to ask whether in an abstract normative way universities should just withdraw from the arena. They will not, they cannot for various reasons. Next, that their entry into the arena, their involvement is extremely difficult. And next, that right now they're doing it very badly in the sense that we're now nowhere near any kind of sensible equilibrium. And I tend to agree along those lines, but let me put it in a slightly different way again in reference to the relationship between inside law and outside law. Universities, to some extent, are operating against the background of changes in American law on the outside. Unbelievably radical, and I think most people would agree, very salutary changes over the last 50 years in terms of the recognition that rape and other forms of sexual assault had been humongously and tragically under-prosecuted in the United States until social changes occurred, over the last 30 years. In that sense, universities are reflecting what's going on, and some might say over-responding to what's going on in the outside world. That equilibrium may have to be adjusted. But let's flip it around. The changes in the rape laws, ranging from the elimination of things like the prompt complaint rule, or virtual elimination of it, to the virtual ban on inquiries into the complainant's sexual history, and any number of other things that most people, I think, would agree are very salutary changes. They did not occur because the judges in the 1960s and 70s, most of whom, were, of course, were white men, had an epiphany, or had some kind of internal, change of heart about things. They were very much responding to norms, mores, social movements, and so on and so on. In that regard, the universities, if I can flip the causation around, are likely to play some role in changes in outside law. We know, for example, that there's a general tropism right now in the criminal law of rape in the United States, vague, erratic, towards an affirmative consent standard of some kind. Movements have gone from the utmost resistance to the reasonable resistance to the force standard, and in some jurisdictions, versions of affirmative consent. I don't know how quickly we will move all the way in that direction. Many people think we should. But that's not going to result from epiphanic decisions by legislators, or at least not that alone. The epiphanies are likely to derive from various kinds of social forces. And one of the social forces is going to come from universities, in part because it's in the nature of universities that they tend to produce more publicized discussions of these matters. And that's in part because, well, maybe it's because it is an economic privilege to go to universities in the United States, and people in more privileged positions get more attention paid to their conflicts. In part because for an arena which is not the public criminal arena, universities are a large but fairly circumscribed one. That is to say, they are a kind of laboratory for social conflict and social conflict resolution, which are likely to produce somewhat more nuanced discussions and resolutions about these things. So in that regard, what may be good about universities having to take on the painfully difficult issues that Jeannie refers to is that their efforts to resolve these things might have very salutary effects for the humongously larger percentage of sexual assault issues that lie in the United States outside the university context.
Briefly, just respond to both. I'm very sympathetic to Jeannie's concerns about the boundary shifting of what should be sexual assault or sexual misconduct. But I want to raise one additional thing that, because I've had a number of the cases involving K through 12, there's a protocol for reporting suspicions of sexual abuse or sexual assault and so forth. The failure to do that, certainly where civil litigation is concerned, it becomes in itself negligent supervision. There has been, I know it came across my desk, if maybe Eugene got the same email, but with UCLA, they started expanding who are mandatory reporters. And certainly with K through 12, it's mandatory reporting to law enforcement. And I'm not sure where the university sees itself moving in terms of mandatory reporting, but from my vantage point, again, mandatory reporting within the university to law enforcement as well.
We have a question, Professor McConnell.
So just encouraging perhaps to become a little bit more concrete about definitions. This morning, Michelle Dauber's slides indicated that Stanford's definition of sexual misconduct is significantly stricter, narrower than that of most universities. So maybe that would be a good jumping off point. I wondered if Bob might explain the difference between Stanford's standard and the usual one. Then I'd be curious to hear what Jeannie and Paul think about that difference.
It's a large and complicated subject, but I just raise a question about your predicate, Michael, about the usual one. I mean, that's an empirical question. And there is no question that the term sexual assault is used in other university codes to cover somewhat more conduct and than is true at Stanford. The question is how one makes something meaningful out of those comparisons, since first of all, there are some universities that actually don't use the term sexual assault at all. Most of them do. Many of them don't define sexual assault in any precise way. They don't purport to. They use the term as a kind of umbrella term and then have different definitions of particular types of conduct. Another issue, and I'm simply pointing to the difficulties of the comparison, is that we have to attend to the operative significance in definitions. Anything that's covered by a sexual assault rule at other universities is illegal at Stanford. I think that's safe to say. Yes, there are certain things that are called sexual assault formally or in a more amorphous way at other universities that are called sexual misconduct here. A reason for that, and it's certainly a contestable reason, reasonable people can disagree over it, has to do with the adjustment of penalties, not so much the scale of penalties, but the presumptions that are operative with respect to certain levels.
But I'm actually not as interested in sort of Stanford versus the rest of the
Oh, I
world
thought
as
you
in the
were.
content.
Okay.
What is the difference? And then I'd be curious to know what people think about the difference.
What
is Stanford's definition? What is another typical definition? What is the ground? What are we arguing about?
I'll let others respond. I simply want to just note that obviously one difference is a question of whether if force is used for unwanted sexual conduct that is not sexual penetration or oral copulation, okay? At Stanford, that may be sexual misconduct. It may be called sexual assault at other universities.
So at Harvard, we just have one category, and that's just called sexual harassment. It's not broken up into sexual assault, it's just sexual harassment, and it just is defined as unwelcome conduct of a sexual nature. And when that creates a hostile environment. And if you look at what does unwelcome conduct mean, unwelcome conduct of a sexual nature is defined in the policy as conduct that is unrequested or uninvited, and that is regarded as undesirable or offensive. So that is the definition. And so within that, you could have verbal harassing conduct, you could have physical conduct, you could have touching, you could have forcible sexual penetration. All of that is covered under that definition, unwelcome conduct of a sexual nature that creates a hostile environment. So I think that's a definition that I think is somewhat broad if you think about the regarded as undesirable or offensive as being something that it's just in the mind of anyone who happens to regard it as undesirable or offensive. But Harvard University recently, I think also in response to the critiques of myself and other Harvard Law School faculty members, they have clarified that it's not just a regarded in the mind of anyone, but regarded as in the mind of a reasonable person. So by putting that limitation, it brings the definition of sexual harassment pretty much within the ambit of what we would see in a federal court under the definition of sexual harassment, that it's unwelcome conduct of a sexual nature. It has to create a hostile environment, and it's got to be in the mind of a reasonable person. And so if that definition is applied, I think faithfully, I don't think that it would cause severe problems. It's just a matter of things like what does a reasonable person think? And of course, that's also elastic.
And I have an entirely different point of view. And for me, any sexual act that's void of consent, consent is with volition, understanding the nature and consequences of which is sexual assault. And we should define what sexual acts are to eliminate the comments one of the question askers mentioned about if somebody says something improper to you or touches your shoulder and so forth, but actually define what are sexual acts, and then question, was there consent to those sexual acts? And did the consent rise to the level of informed consent? And if not, they're more, certainly in that scale, they're more egregious acts than others. But from my vantage point, until universities take it out of Title IX and put it in a separate category of sexual assault, that we have to encumber it with all these other sorts of concepts to make it fit under Title IX.
So my question follows on nicely from the demand for specificity about the definitions. So it seems to me that increasingly terms like sexual assault, sexual misconduct are becoming a little bit similar to essentially contested concepts, where we all agree on the normative dimension, as in sexual assault, really, really bad, sexual misconduct, less bad, still pretty bad, and then there's sort of a political fight over what to include in that scope. I don't know if you're familiar with the campus climate survey here at Stanford. There's a huge controversy over the definition of sexual assault that to my understanding, broadly tracked the California criminal law definition, but the pushback was that it should track the Department of Education definition that is based on consent rather than what was used that was based on force, etc. So if you agree with me that at some point the definitional question becomes political, then the question then is not what is the right definition out there in the world, because there is no such thing. The question is, what are we trying to achieve with the definition? And if that is the way to go, what should we be trying to achieve with the definition? It seems to me there are inconsistent objectives here. One is to have uniformity across universities and between universities and criminal law, but another requests for plurality, because we need a different standard for disciplinary or punitive procedures and a different standard for educational procedures, where we want to tell people this kind of behavior is sort of not okay, right? Like, you want to rethink it, how you interact in these circumstances, but not necessarily go as far as punish them. So where do we look at to build specific standards of what is criminal, what is sexual assault versus misconduct versus nothing at all? Do we look to the psychological literature about trauma? Do we look to something else? Thank you.
So this is a really great question, because there is, for example, this morning there was a call for more information, gathering of data, analysis of information that we don't yet have. And the issue, though, is that often even these instruments that are trying to gather data about what is going on among students, what kind of sexual conduct is occurring, is a project that ends up, whether consciously or unconsciously, shaping what students think of as the kind of conduct that they should feel injured by. So, for example, if you look at the White House survey, the sample survey that they put out on about how that's supposed to guide colleges and how to design their surveys, they define sexual violence as a range of behaviors that are unwanted by the recipient and include remarks about physical appearance. Right? This is the definition of sexual violence that involves remarks about about physical appearance. So then you get the debates about why is it that my school is not considering my experience as sexual violence when I feel very violated by what happened, and I'm outraged that they would call it mere sexual misconduct and not sexual violence or sexual assault. And those debates are really separate from what are we punishing, because as I understand it, the sexual misconduct at Stanford doesn't mean you don't get punished. Right, I mean, it's really just about what you're going to call it for the purposes of information gathering. So even the purportedly neutral project of gathering information so we can at least know what it is people are engaged in and what kinds of things that are happening, that itself, it can't be neutral, because there is going to be a fight about what you're going to label certain things that you're trying to measure. And then whatever choice you make will end up influencing how people feel about the very things that they experience. So if you have experienced an unwanted remark about your physical appearance, it's very different to go around the world thinking, I just experienced an annoying thing that happened. Someone made a comment about my physical appearance versus I just experienced sexual violence or, sexual assault because that was unwanted and that happened. And so I think this is just enormously tricky. There's the question of penalty, and punishment. There's a question of information gathering. There's a question of the shaping of people's inner experiences, whether it's emotional processing, harm, feelings of being violated. All of that is not going to exist separately from the sanctions we have in place for such conduct and the information gathering tools that we're using to solicit people's responses in gathering data. So I think this is a very, very tricky thing. I personally think that we should not really be so concerned about what it is called, but I'm very concerned that we don't go into a world where everything is rape or where everything is sexual violence. There's got to be some sense of there's some wrongs that are more bad and less bad. And there's got to be some tailoring of our responses, both morally and in terms of university discipline. And I believe actually this debate about how dare you not call my experience sexual assault, why are you only calling it sexual misconduct? It's about validation and not feeling validated. And I think we need to be careful not to put the validation project above other projects like accurate information gathering and punishing people according to their just deserts.
Just to pick up on one point there about the role of psychology, not in terms of perceptions recorded in surveys, but in terms of, the operation of the system. And again, let me step outside to an area I know better, the actual criminal justice system. Right now, this entity called the American Law Institute is revising the hideously anachronistic model penal code definitions of sexual assault and rape, which again go back to the 1950s. And one of the things they're contemplating is, let's call it an intermediate lesser included offense. And it has to do with something like recklessness, not purpose, and recklessness with respect to whether consent was established. And it raises all the usual trade-off questions of whether it's better or worse to have that intermediate possibility. One of the questions raised by these very distinguished academics who were doing this work is the effect on people's willingness to report. One thing I've seen in the writing there, it's all very tentative, is that there's said to be some psychological evidence that there are people who will not report if they believe that the punishment is high rather than not so high for various reasons, depending on what they want the punishment to be, what they think the ramifications of a more serious accusation from them can be, and all that. And I saw a footnote to some empirical literature. I haven't had a chance to read that. I don't necessarily trust that literature. But we could just say that if we make the ludicrously naive assumption, it is ludicrously naive that we can identify non-political issues here, non-political goals. So that our real neutral goal is to simply maximize the amount of effective punishment. We then will still have to talk about things like definitions simply because they will affect how we actually get to that optimal outcome.
I just want to say something briefly to the point that I'm probably in this room the person least enamored with psychological data or social science data more generally, particularly as it relates to sexuality. And the example that I use for my students is when we were doing early work on the epidemiology of HIV and going to STI clinics, we had a simple questionnaire gathering data because that was an important part to kind of build this. The first question was, are you sexually active? And got this information back, and of course everybody at the clinic was there because they had a sexually transmitted infection. This young woman had said no, which was kind of unusual to us, so we went up and talked to her, and she said, well, I just kind of lie there. we all bring these kind of, we bring ourselves and our own interpretation of these questions and so on. And besides the problems of people lying with failure to disclosure and all these kinds of things, unwillingness to disclose things, it's very hard to get data on sexuality. The other thing that I say, the three things I know about sex, if I'm a sexpert, and I've been working in this field for 40 years, is that women get pregnant and men don't. sex feels good, and people lie like hell about sex. And those are three things I'm sure of.
All right, let's take two quick questions and we'll go to our next topic. Go ahead, please.
Okay, yeah. I just want to ask about the, I'm the president of FIRE, and we spend a lot of time trying to think about ways to actually sort of rectify and come up with sort of model codes, and we're working for years on one, and we've kind of given up to a degree, and we're trying to, that could actually be in compliance with the OCR. In part because of that definition that you talk about, unwelcome, unwelcome conduct or verbal behavior of a sexual nature. The blueprint definition to us is so amazingly broad. But one thing that we keep on running into time and time again is, and what happened on the previous panel, is since there's severity, persistence, and pervasiveness to various degrees and different definitions of harassment are ways of cabining harassment in to make it not this kind of a completely amorphous, massive monster. That makes a lot of sense when you're dealing with the sort of like inter-office sort of harassment or student-on-student sort of banter harassment. But every time they try to apply it to rape, there's one incidence of rape is of course severe enough, but that always leads us back to, so the whole problem is generated by the fact that we have this weird situation in which we, progress from originally being about harassment took in the category of sexual assault, and we're still trying to apply the same rubric to deal with basically inter-office harassment to rape. Why should we be surprised it doesn't fit very well, isn't very useful for analysis? So I'm wondering, do we have to just rethink, the idea that we are lumping all these things together, I think is so much a big part of the problem.
Okay, before you answer, let's go ahead and take the second question, and we'll give them time to answer both questions.
And I can ask mine later. I'm specifically interested in discussing the definition of incapacitation, so either now or later.
Let's do that one later. Thank you. Okay, go ahead, please.
Yes, do you mind? Okay, so the question of how broad the definition of sexual conduct has become, surely it has something to do with the sort of convergence of sexual violence ideas and sexual harassment ideas, right? They used to be quite distinct. Sexual harassment was a workplace thing and civil, and sexual violence or sexual assault was criminal. And now we've got elements of sexual harassment in our criminal law, and we've got large elements of sexual violence in our civil law of sexual harassment, as well as in the universities. And yes, I think that one of the clunky things that's happened in this area is the interpretive move, say sex discrimination, also includes sexual harassment, which has been established for a long time, and then the move that's more recent, which is that sexual harassment includes individual acts of sexual violence, and that last one, is the one that really brings us here today. I think that's the one that has caused a really big change in the university landscape in terms of universities' responsibilities and what they believe that they're supposed to do to comply with Title IX. Because without that move, the idea that individual acts of sexual violence are forms of sexual harassment, we wouldn't really need to, the universities would not have the obligation to remedy those individual instances. And as you mentioned, Greg, the hostile environment is all important in sexual harassment law, right? Because it's got to be, as you say, severe, pervasive, persistent, in order to be sexual harassment. It can't just be like you made a lewd comment. It's got to infuse the environment and make it hostile to the person, but on the basis of sex. But there's been also now some fuzziness about what hostile environment actually means, because when you start saying there's one incident can cause a hostile environment, it starts awfully to sound like, well, it's all subjective, like it's hostile to you because it's actually prevented you from being able to attend your classes and take your exams, and you can't study as well, and you are throwing up and losing sleep, and therefore the environment has become hostile. So there's a way in which the hostile environment was supposed to be almost like an objective idea of like there's an environment out there in the world, and it has become hostile as a result of these acts. It's now almost become the opposite, like the one act, it may have been that somebody was groped without consent. But then that meant that they then could not study, concentrate. They were, they were sleepless. They were depressed. They became extremely distressed and could not finish their semester adequately, and that becomes hostile environment. So I think that has also happened. The meaning of hostile environment has shifted, and recently, the OCR, the Office of Civil Rights and the Department of Education, has pressured at least one school and probably others to drop the hostile environment requirement and said, you really shouldn't be defining sexual harassment as unwelcome conduct of a sexual nature that creates a hostile environment. They have said, and maybe I'll quote from it, that you should define sexual harassment, quote, more broadly as any unwelcome conduct of a sexual nature. Defining sexual harassment as a hostile environment leaves unclear when students should report unwelcome conduct of a sexual nature and risks having students wait to report to the university until such conduct becomes severe or pervasive or both. So here is the OCR actually saying, no, we want to change the meaning of sexual harassment so that hostile environment is not the test, it's just unwelcome conduct of a sexual nature. My school hasn't gone that far. We still have hostile environment, but this is the federal government putting its weight behind this extremely broad definition and taking away some of the things that do cabin the conduct to a level where we can actually, say this is conduct that we really consider unacceptable in our community.
Want to add anything?
No.
Just to say that, first of all, I mean, what Jeannie has described is, of course, a species of a general phenomenon in any legal system, and I don't have a good name for it, so I'll call it the biochemistry of discourse, and that is that terms that have some valence or some role in a particular context then get transferred to another somewhat related context, but not an identical context, and you can bring in some other cliches here like path dependence or reification or whatever. Second, rather obvious point that when we come to the kind of question that Greg just raised, we realize that it's always going to be naive to draw a substance-process distinction, of course, because very vague standards become much more precise formulas once we find out who's actually interpreting the very broad standard and doing any kind of potentially precedential interpretation.
Let's go to our next question about consent and incapacitation. Why don't we start with Bob?
Raise the question again.
If consent should be the standard for sexual relations on campus and what that means.
I'm ambivalent about this, but I can see a very good argument for doing so, in part because, again, if we look at what I clumsily call the tropism of the American legal system, it is moving in that direction. If you take jurisdictions in the United States right now, none still follows the hideous old utmost resistance standard. California, for its rape law, uses the force standard, which one might think of as, if you put it in historical terms, it's a kind of 1970s stage of this progression. Others have taken it a little farther and said that it will be, let us assume we were talking about rape for the moment, in terms of penetration. Some have said that crime has occurred even without proof of resistance or force, so long as there was non-consent. And then the last step, adopted by some jurisdictions, obviously, is that it is criminal, depending on the act involved, unless there's affirmative consent. So I'm stepping back a bit, and I think the world is probably going in that direction, and I don't know when it's going to get there. I think an important thing to say is that if we get there, we're going, and we are obviously in terms of campus rules right now in California, because putting aside levels of punishment and definition, all universities in California must forbid sexual conduct, well, I'll use that term broadly for a second, without affirmative consent. That's simply the law in California now. We will then get into the next round. We're already into the next round of interpretations about what an affirmative expression means, whether it must be expressed, what it means to be implicit, and of course getting beyond the naive assumption that we're always talking about a single moment in time as opposed to a continuing course of conduct and so on and so on. So number one, we may be there before very long. The whole world may be in that place where affirmative consent is the standard. Second of all, the kinds of questions that are going to be raised in interpreting an affirmative consent standard really most of them have to be addressed under other standards anyway, which means I think it may all come down to how we address those harder questions anyway.
I'm a great believer in affirmative consent, and when I started doing sex research in 1971 and published the first article I did in 1973, if I was asked at the time, will there be gay marriage or transgender rights and so forth, I think that's inconceivable. But I agree with what Bob had said. I think 30 or 40 years from now, it's going to be inconceivable that there wasn't affirmative consent for every step in a sexual encounter. There are many other sort of issues that involve this, like blanket consent. By California law, consent expires, and so how we integrate that into this? Consent to one step, does it give consent to below, above, the nuances of verbal versus nonverbal, and all those issues that could involve misinterpretation will come to the foreground as well, and whether it needs to be verbal. And if yes means yes, it's that. The second point of this, and that Lee Douch and I, who's Deputy Attorney General, have been writing about that, requiring of college kids is a little too late. Sex starts around 12, 13. If college kids are going to know the drill, you have to start at that age. And so our emphasis has always been on teaching affirmative consent through role-playing and the school system and so forth, and that's a better way of kind of expanding the imprint of this. Plus, they also have to be taught how to reporting violations within it. But just saying that you need affirmative consent to each step is kind of without teeth unless you teach young people how to report these things. Most sexual assaults go unreported, and most sexual assaults are by acquaintances. And most women who report being sexually assaulted, like 42%, say it happened before the age of 18. Again, waiting for college is way too long.
So consent, I think the question is should consent be the standard? Should consent be the dividing line between sex that is okay and fine, maybe not ideal, but we're not going to discipline it, and sex that we're going to say was not allowed and there are going to be consequences? Well, I think that in California, yes, there's affirmative consent, but in a lot of schools, like for example mine, the word consent doesn't appear even once in the code, in the policy. It's the standard is unwelcomeness, and that's different, I think, from consent, just unwelcomeness, because that's a subjective, I felt that this was unwelcome, and that it would be, and then we have the reasonable person, and it would be that way in the mind of a reasonable person. So there's the unwelcomeness, there's also unwantedness, which is also separate from consent. I mean, you could define consent as unwantedness, but you could also see consent as a very distinct concept from unwantedness. It's one thing to say, I didn't want this to happen, and to say, I didn't consent to have it. It could be that you didn't want it internally, but you did consent to it. So there is a distinction. A lot of schools have an unwantedness standard. They don't go to consent. Within consent itself, you could define it as positive agreement to engage in certain sexual activity, like you made an agreement to engage in it, like when you agree to buy somebody's car or like enter into any other contract. Or you could think of it as consent is communicating willingness, that I communicated willingness to do something. Not so much agreed, but I communicate that I'm willing. Or you could think of the lack of consent as communicating unwillingness, right? So you could think of it that way. And there are all kinds of ways, even within the concept of consent, even within affirmative consent, there are infinite varieties of types of affirmative consent. Does it include verbal conduct only, so that only verbal conduct counts, or does it also mean nonverbal conduct? And if it also includes nonverbal conduct, then what does it mean? Can you consent by returning someone's kiss? Or not really, because you didn't, because that itself is an act for which there is no affirmative consent. How do you tell the distinction between the actual sexual activity and the thing that would indicate or communicate willingness or indicate a positive agreement? So I think all of that is very complicated. But I'm not sure that affirmative consent is more complicated than the centuries of debates about what consent is, even when it wasn't affirmative consent. I mean, it's always been complicated to figure out what it means not to consent. And I am not convinced that we're entering a world where this is an impossible nut to crack because we're now in an affirmative consent world. I think it's complicated, but I think consent has always been complicated. I do agree with Paul that maybe those of us who have raised questions about the desirability of affirmative consent and are either on the fence about it or against it, I think we're tilting at windmills. I think that in 20 years, affirmative consent will be the standard, and that will be considered, I think at schools already, it's considered to be weird if it's not something like an affirmative consent standard. And I wanted to get back to the question of intoxication, incapacitation. I think it's obvious to everybody that if you have sex with somebody who is passed out and incapacitated, like their limbs can't move and things like that, that's sexual assault. But of course, then you have to think about what about impairment and how much of an impairment and intoxication. At some schools, and definitely ones in California, there are some schools where you can't have sex with someone who is not sober, at least in terms of the law that's on the books. The rules that are on the books that say if you have sex with someone that's not sober, then that is sexual assault. And this is the kind of thing that I'm talking about where everybody has had sex with someone who's not sober, and that means everybody is open, vulnerable to being accused of sexual assault. And I don't think that's a laughing matter. I think it puts everybody in the position of being at any moment able to be accused, and validly so, because that's what the rules actually say. I think that we need to, again, attend to the differences. It's not popular, but I think we need to attend to the differences between incapacitation and levels of impairment and intoxication and being tipsy. All of those are levels that take you away from complete sobriety, but do we really want a world in which we say that anyone who has had a drink is not capable of consenting? And I think that there are lots and lots of reasons that we wouldn't want that. For one thing, the discriminatory enforcement that I mentioned earlier. The Department of Education has put out a report about K-12 discipline against kids, African American kids, and have found that African American kids are disproportionately likely to be disciplined in their schools. And this is general discipline in K-12, not just sexual. But when you have that kind of disproportionate enforcement of discipline, how could we not expect that having a wide standard that basically applies to everyone would not also result in a kind of disproportionate enforcement against populations on campus who are already marginalized or seen as sexually predatory?
Do you want to follow up on your incapacitation question?
Yes, and also a comment on affirmative consent. I'll make it only two sentences, which is that it is extremely hard when you're in the middle of one of these hearings, and I have been very closely associated with one, to prove a negative.
Yes.
And affirmative consent is such a huge difference in culture from every single movie and TV program we have ever seen that has any romantic component, that every student has ever seen and everyone in this room, every single one does not have affirmative consent. So that is such a huge difference from culture that it's, then you take that and you put it into a hearing situation and you have to prove this negative. It's very difficult. And incapacitation ties right into that. Incapacitation in our specific case was that the boy was found guilty or responsible because the girl was found to be incapacitated because she took her shirt off in front of 3 or 4 other people and then came back later and they engaged in consensual, well-documented sexual activity. But they said that she was incapacitated because that was something that was not her normal behavior. And so the definition of incapacitation, how do we get that? Your definition is fine, and it's actually very close to what is in many sexual assault policies in the country. Your definition of incapacitated means asleep or unconscious or unaware that sexual activity is occurring, the how, what, when, where of sex. Where that definition is then often qualified by if the complainant, usually the girl, had been drinking anything, then therefore, it's like they have these two definitions. I can show you specific examples. Occidental University, specifically Occidental College, they qualify a very clean definition with this other crazy definition, in my opinion. So I'm interested in your opinions on how we can define consent in terms of incapacitation that is both consistent with our culture and consistent with logic.
Let me hear Professor Weisberg or Professor Abramson. Do you want to address that? And you didn't address intoxication either, so if you
I want to add, I enjoyed so much of what both Jeannie and Bob have said about these things that I just want to add a little nuance to it, which is somewhat related to this, which is that the consent is bifurcated. It's showing a willingness, a voluntariness, and so forth, but also understanding the nature and consequences of the act. And a lot of work I do is with the mentally ill or developmentally disabled, and that's critical in that. They can show a willingness, but do they really understand the nature and consequence of the act? So anything that would diminish the intellectual capacity, I only think about it in those terms, drugs or alcohol and those kind of interventions, would diminish raise the question of, did they really understand the nature and consequences of what they were getting into?
Professor Weisberg, did you want to add anything?
Just to add that obviously lines would have to be drawn in terms of the condition of the person who may be impaired, because there will be degrees of impairment that don't meet whatever the neurological definition of unconsciousness is, which nevertheless, I think by some objective measure would constitute incapacity to meaningfully consent. Playing with that line is going to be difficult, but it gets worked out. But as with so many other things, then the issue is going to flip over, and the question is perceptions thereof. And then we're going to get into something that the legal system tries to avoid for a while and then can't. In other words, the hideous subjective-objective distinction. So to move just out of intoxication for a moment to get back to the standard that Jeannie was talking about, she was suggesting quite plausibly that terms like unwelcome and unwanted seem subjective. I would speculate, I don't know, that as those things get worked out over time through lots of adjudication, whether formally presidential or not, somebody's going to say, of course, we didn't mean just subjectively unwanted, but what a reasonable person observing that behavior think was unwanted, and so on and so on. And at least as we get into the more nuanced layers of impairment that are still meaningfully inconsistent with consent, the analysis is going to shift over to the other side unless the human race is going to change, simply because that's the way it's happened in criminal rape law.
Professor Suk, did you want to add anything on this point?
I can wait for other questioners.
Go ahead.
Yeah.
Okay. So Jed Rubenfeld, a Yale law professor, wrote an article, I'm sure you're familiar with it, in 2013, and I've got this up here so I can get the title correctly. It was called The Riddle of Rape by Deception and the Myth of Sexual Autonomy. And he's wrestling with this question, and I wondered what you thought, Professor Suk, about his, trying to use rape by deception as a way to distinguish between, the force requirement and consent. Are you, and I thought I'd let you summarize the article if you're, or maybe you've written about it and you can refer us all to that. Or should I?
Yeah. I haven't read it since 2013, sorry.
Okay, so he said his summary, this is the abstract says, this article argues against the idea of sexual autonomy and against the understanding of rape as unconsented to sex. A better understanding, it is argued, can be arrived at by comparing rape to slavery and torture, which are violations of a person's fundamental right to self-possession. This view of rape can explain the rejection of rape by deception, which is kind of the test case where somebody, a man said, I'm an Israeli bachelor, but he was really, a married Palestinian man, and he was accused of rape by deception, which would then, of course, if we said I'm, a wealthy, heiress, and I want to have sex with you, then I would have raped somebody because, I've deceived them. I mean, it could be extended that way. Anyway, so this view of rape can explain the rejection of rape by deception, which current thinking cannot. But it will also suggest that rape law's much maligned force requirement may not be so malign after all. And I think for everyone, it's a very interesting article. It's on the internet, and he's wrestling with this. And I mean, there's a lot. I think there are a lot of people unhappy with it, but I think there's a logic, a 60-page logic to it. exactly. I've wondered if you had any thoughts. But.
Yeah, I think that this example, one of the example that you brought up about the Israeli single guy someone who says he's an Israeli single guy when he's actually a Palestinian married guy. This is like endlessly entertains my students in terms of discussions and backs and forths. It's probably about the most lively discussion I have every semester about whether that vitiates consent, being lied to, whether it vitiates consent. And it's really interesting because when I first started teaching back in 2007, students generally thought being lied to was not an issue that went to consent. If you agreed to have sex with someone because they told you they were a Brazilian doctor, but they turned out to be, a French lawyer, and okay, I'm sorry, but that you still consented to sex. But it's really interesting that now we're in 2016. Many, many more students, probably the majority, from my very unscientific, observation of my classes, believe that vitiates consent, and that if you are lied to, and that you don't understand some of the fundamental attributes of the person, and it could be something like the person says they're a woman, but they're a man, right?
There's a movie about that.
There's a movie about that. I know which one you mean.
Crying Game.
Crying Game. And there's an English case recently where it was a woman a girl who pretended that she was a boy, so clearly, and courts are generally with gender. You might consider it more fundamental to what you need to know about the person to know whether you want to have sex with them, whether you're gay or straight, whereas their profession or their religion or their marital status might not be. But to me, these are not about fundamental distinctions between an autonomy analysis versus a force analysis. It's really just, it's all a matter of degrees. Like what is the information you need to know to make an informed decision to agree to something? And we may all disagree about where on the spectrum we would draw the line, but there is some line to be drawn. I believe all of us would think that. So I don't think it's a categorical thing.
I want to add a little nuance to this. I agree completely with what Jeannie said, but Terry Gross, who's in this audience as well, and I worked on a case involving a schizophrenic man and a priest with AIDS. And the priest had told the schizophrenic man that he'd sent a prayer to a monastery in Greece and that he'd be protected from HIV. And so you get these questions of fraud. And what's criminal fraud versus a disingenuous or insincere kind of thing that one might do as part of a seduction. And although we may think, however we're applying it in the description with the Israeli case, which you told me about a number of years ago, the question that became up to us was, where is that line? And so it's always, where is that flexible line in this?
Professor Volokh?
The affirmative consent standard strikes me as a very interesting debate, and I see a lot of arguments in favor of it, but I'm trying to figure out how it plays out in practice once you get nonverbal consent, which I assume everybody is going to consider sufficient. Maybe not everybody, but that's the dominant view as I understand it, is that nonverbal is enough. And then how it plays into mens rea. Now, it's possible, and I don't know, we haven't discussed this, but it's possible that some of these rules are being enforced on a strict liability basis.
Yes.
But assuming that there is a mens rea requirement, and not even necessarily a standard criminal law like recklessness or knowledge, but negligence. So I take it the way this would happen often is man is accused of having sex with the woman. The woman says he didn't use force in the threat of sense of violence. He didn't threaten me with anything, but I was just, he just started having sex with me, or often it would be he started, let's say, fondling me in a particular way, and I just froze up. And I didn't do anything to suggest my consent, but I just sat there.
Right.
And he says, well, I assume she's telling the truth about what she thought, but the way that I perceived it was that she was maybe kissing me back or caressing me while I was doing this. And you know, I thought that was that coupled with the fact that she didn't push me away, Not just that, but all of that put together, I thought, and I think reasonably thought, that she was okay with it and she was consenting to this. Whether it may not have been super enthusiastic, but certainly consenting. And the problem is, I take it hard enough is for us to remember what exactly was said. Well, was she caressing or not? Was she kissing me back or not? I mean, people have recollections of that, but those recollections, I take it, end up being very skewed by their own self-interest often, but also just by their perception of what they expected to be going on. So my question is, whatever the quantum of proof you have, whatever the procedures you have, how can you really have something where a lot is at stake, riding on a question such as, did he reasonably perceive that she was caressing him or kissing him back? Is that something that we think that any sort of reasonable adjudication process, that's a kind of a fact-finding that can be done, especially in light of the mens rea background?
Well, certainly the cases I see as criminal matters, was this reasonable? A woman gets naked in a hot tub, she just wants to enjoy the hot tub, what else? Guy sees it as a green light for intercourse. Woman engages in oral sex, guy sees it as a green light for intercourse. And he's appealing to a jury. What was I supposed to think? She took her clothes off, got naked in the hot tub.
But I think you also say, but not only that, but when I first started trying to, say, penetrate her, I thought she was caressing me.
Then she's screaming. She's screaming then.
Oh, fair enough. If they're screaming, then that's an easier
Yeah, well, that's not hypothetical.
That's what I see these in criminal court.
I'm comfortable saying the screaming, except in unusual circumstances, is a sign of lack of affirmative consent.
So, but his argument is that, she got naked in here, so that was a green light for that. How was I to know otherwise? I see atypical examples of those, but they're nonetheless examples of this misinterpretation. So how guys can misinterpret women. I mean, even though I talked about how terrible psychological data is, you ask guys, if a woman smiles at you, what's she doing? What does she want? A lot of guys say, well, she wants to have sex with me. Men misinterpret these cues. So the necessity of affirmative consent, from my perspective, is it formalizes yes means yes. So you basically exclude male ideas about women's friendliness or women's kissing or women whatever else, because men will take that to perceive it as green light to subsequent events as well.
But I'm asking what situation where she doesn't say yes, and nobody expects her to say yes, because lots of people don't like to talk about such things or do such things. But he says, she was caressing me, she was kissing me back. It seems to me, that's the kind of thing which is easier to make a mistake than, oh, she's in the hot tub, therefore she's up for something.
I agree with you completely.
So I think that under like a faithful application of affirmative consent, that would be a lack of consent, because she didn't affirmatively, either verbally or physically, indicate or communicate consent or positively agree. And I think you're asking this question because you would be troubled by that result.
No, I'm asking how the mens rea overlays.
Right. So the mens rea is, so for example, in Massachusetts, the state where I live, there is no mens rea requirement. It's essentially strict liability for the accused in rape cases, right? So, and that has led to, when we have this debate in the university, people say, well, even the criminal law doesn't require a mens rea for the accused person, so how is it that the university ought to require a reasonableness requirement, that he have been reasonable? It's just strict liability. So I think that there is with affirmative consent, it goes, because you're looking at, was there verbal indication, was there physical indication, it almost makes it more of an objective inquiry. Like, did you actually communicate your agreement? Did you positively do something? That makes it more objective, which means that the subjective perception of either party is a little bit less relevant than it would have been in a different kind of standard. And I do think that is true about affirmative consent. I will say, I think you used the word enthusiastic, that she wasn't doing it enthusiastically. Well, the word enthusiastic actually does appear in many sexual misconduct codes in many universities today, including many, many in California. Because one of the ways that they've implemented affirmative consent is not only to say that it has to be unambiguous and positive, but also enthusiastic. So the line, the standard line would go something like, only a comprehensible, unambiguous, positive, and enthusiastic communication of consent for each sexual act qualifies as consent. So even the concept of enthusiasm has now, and this is what I mean by the expanding, first you go with positive, and then it's like, no, it should be enthusiastic. And some codes say creative, imaginative, and sober. And so these are codes that are like reported to the federal government in the annual security report as the standard for consent that these universities are using. But I think that those of us who are troubled, it's because of the question that was asked, this excellent question from this morning about, I think essentially what it was, how much over-inclusion and how much under-inclusion are we willing to live with? And that's the all-important question, because if you think, set the default at no sex or no sexual activity, and then if you get accused and you didn't abide by the affirmative consent requirement, even though you didn't know, whatever, or maybe even the other person didn't at the time feel that this was a problematic thing, it still would be a violation. And the default is set that way, and so there we're going to have some over-inclusion, but maybe it's a level that you feel okay with, given the state of gender relations in our country and the power dynamics and the likelihood of men misreading cues. Maybe in this case you didn't misread, or maybe in this case you did misread, but anyway, the default is set in a place where there's going to be a bunch of over-inclusion, and you're willing to live with that amount of over-inclusion to deal with the imbalance in bargaining power overall in society between men and women. That's not where I would draw the line ideally, but I think that is a coherent argument, that you're going to capture a whole lot of people who maybe are innocent or didn't really do anything wrong, didn't know they were doing anything wrong, or know they were doing anything that was unwanted even, but they're still going to be captured by this. And I think the affirmative consent debate has to be upfront, and in some cases they haven't. I think the advocates have been upfront about this acceptability of over-inclusion at that level. Because we all know that there's going to be over-inclusion no matter what code you adopt, and there's going to be under-inclusion no matter what code you adopt. So it's always a situation of how much of each can we live with and sleep at night.
Professor Weisberg.
Well, first of all, I know from decades of being a fan of Eugene that when he expresses honest puzzlement about a doctrinal issue, he's probably kind of figured it out, which I think he has here.
No, I'm actually honestly puzzled about this.
I mean,
I'm even more after what Professor Zook said.
You've accidentally correctly figured it out in the following sense. This business about mens rea is important, but in a funny kind of way. Now, let me challenge what Jeannie said about Massachusetts law. Who am I to try to refute what the professor says about her own state law? It is called strict liability, but there are many who will say there's never strict liability here. Because the movement of the law is going to be, at least in cases where, how about this? It's going to be about framing, and it's going to be about burdens of proof. So let's just say the move to an affirmative consent law, putting aside standard burdens of proof in criminal cases or in university cases, is going to be towards requiring the accused to at least describe some conduct, if not express words, by the other party that could be construed as affirmative consent. Then it's going to be a question of whether a reasonable person would really construe that as affirmative consent. If you then say that we make that decision and then there's no mens rea, it may not really matter very much if it's reasonableness, because the reasonableness is going to be the flip side of negligence, and so on and so on. In which case, and there are lots of arguments about this, it may all turn out to be, one, burdens of proof, number two, the kind of rhetorical framing of things. So, for example, if in effect, negligence with respect to misunderstanding the reasonableness of consent becomes sufficient for the crime, there will be people who say, I was accused of committing rape negligently, which is bizarre in many ways. And of course, the Sex Act was purposeful. So my sense is that, yes, there are jurisdictions that say there's no mens rea. There are some, like Pennsylvania, that have moved in somewhat in the direction. It's simply different sides of the same debate, really. But I don't think there's strict liability here. I think it's just the way it's framed.
Okay, we have 5 minutes, and I saw 3 questions. Mr. Roth, you're waiting the longest. Go ahead, please.
Thank you. So I think we can stipulate, having heard this conversation, that both the definitions of consent and incapacitation are incredibly nuanced and complex and evolving. Having represented respondents in these proceedings, it seems a bit like an academic exercise when we're talking about what happens in Title IX, in the Title IX adjudication context versus in a courtroom with standards of procedure and evidence. And that's, I guess I didn't present it in the form of a question, but well, I'll do it this way. Is it not just an academic exercise when we're talking about the way these cases actually get adjudicated in different contexts around the country?
You're right to say that it's very difficult and nuanced and those sort of things. And the factual underpinning of all these cases are so different, because I could bring in cases that mention the developmentally disabled or the mentally ill. And, you know, the thing that's really critical at this point in time is, you know, consenting. Do teenagers have the right to consent in those sorts of relationships? And taking in Ray Galt, do they have the constitutional right to do that, and whatever else? I don't know if there's any simple answer at this point in time. I think they've taken on a case-by-case basis with a general notion of that, you know, consent underlies some way of demonstrating volition and some evidence of understanding the nature and consequences of the act. And the question was informed consent given.
Yeah, it's tough when you can present experts and cross-examine witnesses, et cetera. That's a way to fact find. It seems, again, without those protections that.
Well, that's why I say it shouldn't be in the university. It should be in the courtroom.
Right. That's your.
Yeah.
All right, let's go to our next question, please. Go ahead.
There's been a lot of talk about how affirmative consent would play out in a hearing. And isn't the easiest way to think about it just that it reverses the burden of proof from the accuser to the accused? Because, you know, if you have to prove that you gained affirmative consent versus the accuser proving that consent was never given, basically. I mean, isn't that just one way of thinking about it? We're changing the burden of proof with respect to the consent portion.
Let's just have one answer to this. We have one more question.
I mean, I think that's true. In fact, I mean, there are complicated constitutional issues which I think tend to get avoided completely here. You know, it has to do with whether something is an element of a crime or an affirmative defense. But as a matter of fact, yes, I think that's what's going on.
Okay.
Next question, please.
Yeah, so it seems that there is a clear benefit to affirmative consent, and that is that it provides a focal point and a bright line that sort of cuts through all the misunderstanding problems that we have now. I see two associated costs. One is one that has come up already, which is this idea that until we get to that point where that acts as a commonly known focal point, there will be people that will not live up to the affirmative consent standard, and there's no way they would have known how to live up to this affirmative consent standard. But the answer I get to that is fine, that might be a problem, but it will be temporary, because we will get to that point where everyone knows, and at least we'll have negligence mens rea satisfied, because if you didn't know that you had to obtain affirmative consent, well, you should have known, you're at least negligent. Another cost I see that I don't think is discussed as much is this problem of the state sort of prescribing a script on how to have sex. And I think, personally, I feel that is an issue, right? Maybe it is an issue that should be trumped by the more sort of heavy desire to create a focal standard, but at least we should acknowledge it as a cost. So to what extent is creating a script on how to have sex an activity, you know, that's historically repressed and difficult for a lot of people, a problem? And if it is a problem, how should we balance it against the benefit of creating a focal point?
Okay, so so you believe, and I'm not sure I believe it, but maybe you're right, that eventually, there's going to be a time lag between when we put in this affirmative consent standard, we educate people widely about it, we discipline students. There are going to be some people who get caught in that transitional period where they didn't quite know that this is what they had to do, but eventually all K-12 education and college education will take care of this, and then we'll have a whole bunch of adults out there in the world who are asking each other for affirmative consent and getting it for every single sexual act they engage in. Right? That is possible. I don't think it's likely, but maybe. But in the transitional period, we're going to have some unevenness where lots of people are doing it this way, and lots of them are technically in violation, and then we got a whole bunch of the selective enforcement problems that I discussed. But maybe. I would be curious to know from others in the audience if they think that eventually, if you set the standard this way, we will be just changing the way people have sex. And we know that that is something that has happened over time. I do believe there is less of a sense of that it's okay to force your wife to have sex today than there was during the days when we didn't have marital rape punished in the criminal law. I think that that is true, that the law and the rules do shape the way people behave, including the way they behave in sexual matters. So maybe this is just part of that we will just have an affirmative consent type sexual activity among all people who've been educated in this system, and eventually that will take care of it, and we won't have these unjust cases of people who just were acting innocently and they got caught up in something that they just didn't even know was wrong. I think that I think that there is the separate question that you asked about.
So is that a problem? If we're in that world, have we solved the problem? Because not everyone knows what the standard is, so there's no, oh, I didn't know, I'm sorry.
Right. Eventually, I mean, some people are still going to think that it's a burden shifting, and somehow that is unjust. But if we're in a world where everyone knows that this is the way you're supposed to have sex to not run afoul of the law, then, and everyone, you know, and of course ignorance of the law is no excuse, but will it be in a world where everyone's been trained, extensively trained by their schools, by their teachers, and by, you know, sexual education programs at universities to do it this way? And so then you're going to be less worried about the kid who like is somehow innocently caught up in the system. And I think maybe that is, I think it has to do with your prediction about whether in fact people are going to change to that extent so that these rules actually will then fit what it is people are doing, or whether there's always going to be this extreme gap, or at least some kind of gap, so that you're going to have the problems of selective enforcement or discriminatory.
So imagine we actually got to that world, and I see your point that it might never get. Is there a problem with that world? Is there a cost in that world where we're all having sex and we're this?
Right. The cost that I think that you have just put on the table, that I am, you know, have some broad sympathy with, is, well, people can have sex, you know, they're social mores. People have sex in one century differently than they did in another century, and that's just the way the world goes. But there's something that feels weird, I think, what you're saying about us doing it because the government told us that this is what we're supposed to do it, or because while you're in college, you know, the adults, the grown-ups in the administration told us that this is how we're supposed to have sex. And I think that it's always been the case that the university has prescribed certain norms of behavior and how to treat people. And sex is one of those areas that right now has a lot of focus. But at one time, it used to be that women couldn't go to men's dorm rooms and vice versa, and there was lots of, you know, the parietal rules, and we got out of that by emphasizing the autonomy and the freedom that students enjoy. But we're moving it back into a situation where there's more of a sense of the university needs to take care of people so that they don't get into an unsafe situation. And so we're just moving more into that world. And, you know, I feel like this is just, there's an up and down in kind of an ebb and flow of how universities take their role in terms of protecting people versus seeing them as people who are free to do things. And we're just right now happen to be in an era where we're much more concerned about student safety and about making sure that they are adequately protected from dangers. But basically, I mean, there is something creepy, I agree with you, about our sex lives and the things we do in the bedroom changing because of what the government tells us. But in some ways, of course that's what happens because we have rules about force and non-consent. That's a version of that too. But there's still some residual feeling of discomfort about this. And I think that this comes down to things like, and when you look at the way the universities, in this paper that I wrote called Sex Bureaucracy with Jacob Gerson, we detail some of the university instructions to their students on how to have sex. And it's always in the rubric of sexual violence prevention or sexual health. And they, you know, and there are examples and of how to do it, like scripts, actual scripts that lay out how to ask for consent and get it. And that is, that's the university doing it. It's also dictated in some way, in some loose way, by ideas about the federal government needing them to do prevention activities in order to comply with Title IX. So it's all part of the bureaucratic web. But in some ways, it is still roughly consistent with the university's mission to train people to be basically good human beings. And so you might think that this is not one of the areas in which universities should be training people to be good human beings. But then you've got to buy into some idea that sex is different from other ways in which
All right, thank you so much. And I think the panelists would be willing to entertain any questions during the break. We need to wrap up, but I told Professor Abramson he could take
I just have a quick
last word.
response to that. I agree with everything Jeannie said, but I wouldn't use creepy. What we're really talking about are the incipient forms of sexual relationships, or beginnings. I mean, once sex has been routinized and normalized in a ongoing sexual relationship, these matters are irrelevant. But we've changed, like rape law was originally, it was a blanket construct. It was, you gave consent in perpetuity. And that's changed. We have a cultural shift in this. There'll be a cultural shift in looking at it this way. And if you're beginning a sexual relationship, you have to have verbal consent. Yes means yes.
All right, thank you very much. And thank you to our panelists.